All right, the Public Defender Board of Trustees regular meeting will be called to order. Will the acting administrative director or the secretary please call roll?
Yes, Your Honor. First Board of Trustee member, Robert J. Torres, Chairman.
Present.
Second, Alberto C. Lamarina III, Trustee.
I think I'm the vice chairman. It's just a clarification. I'm
Yes, Your
present.
Honor. Vice Chairman, correct. Member Attorney Jacqueline Terlahi, Guam
Present.
Bar Secretary. Mrs. Donna Munya Kanata, member.
I'm present.
And Ms. Dr. Christiana Whitman, member.
Present, thank you.
So all the members are present and notice of the meeting was published in accordance with the open government law. And so the first item on the agenda after the proof of notice and determination of quorum is the approval of the minutes from July 23rd regular meeting. Can I entertain a motion to approve the minutes?
I'll move to approve the minutes subject to correction.
All right, it's been moved by the presiding judge. A second.
I second.
Seconded by trustee Whitman. All those in favor say aye.
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 There being no objection, the meeting minutes are approved subject to correction. Then under old business, we now have the financial status update and the allotment releases. Mike?
Okay, thank you, Your Honor. Good afternoon, Board of Trustees. PDSC received a total of $908,403 after the last board meeting, which brings both PDSC and APD at 92%. We are approaching the end of the fiscal year, and there are two more allotments expected for a total of $605,610 for fiscal year 2024. For the ICJR, as of August 31st, 2024, expenses were $151,705 for personnel and $23,052 for travel supplies. The balances were $10,397 for personnel costs and $841 for operations. In September 2024, PDSC had received additional funding for the ICJR of $31,489. The ICJR funding has also been extended to end rather than June of this year. It was extended to end in March 31st, 2025. The first invoice for Stop 22 was $6,518 for August out of $26,410, which was approved. Going on to EJC, invoices for February through August of 2024 for a total of $178,691 were submitted to DPHSS. We have received $95,728 with the amount pending at $82,963. We will be contacting DPHSS for the remaining balances. WizCare, for the legal services for the veterans, PDSC has submitted an invoice for July at $2,171 and August for $2,225 for a total of $4,396. Payment for all those invoices has been received. That's all I have for the financials.
Mike, did I hear you correctly that there's 605,000 still remaining on the last two allotments?
Yes. 605,610.
Okay.
Just
All right.
one question, if you don't mind, Chief Justice. I
Sure.
wanted to ask about the last meeting. There was a report that the Civil Justice Center had submitted invoices and those were not paid as of the last meeting. There were a couple of references to things that have not been paid. Have those also been received in the interim between July and now?
Yes, they have.
Thank you.
All right, any other questions for Mike? If not, let's hear from the PDSC Executive Director on his report.
Thank you, Chief Justice. So we submitted numerous reports regarding electronic monitoring. I think those are pretty self-explanatory. As it shows, a lot of them are ineligible, but sometimes we still argue before the judge because some of their restrictions we believe are not necessary. And so even some that are ineligible by probation get approved by the court. So those numbers are there as well. I think it looks like we have 28 pending applications waiting for the court to rule on them. And then we also submitted a report on our pretrial criminal case status. This one is, it says 1,810, but many of these are for bench warrants. There's like 840 outstanding bench warrants. And if you see the initials here, a lot of these are for attorneys that are no longer with the PDSC. So when a bench warrant we call them ghost attorneys, but once a bench warrant gets executed, it gets reassigned to an attorney in that courtroom. That's why if you look, the longer you've been at PDSC, the more warrant the clients you will have, right? So all the old timers have like way more bench warrants than all the new younger attorneys. And so and then we also broke it down by courtroom, right? And so you see Judge Sokola, she still has 56 bench warrants that are assigned to her, but of course once the bench warrant comes in, right, the court will reassign it, and then we'll find out who it goes to, whether it's Tolentino or Judge Terlahi. And so even Judge Tolentino has like 85 bench warrants, and obviously he has a lot of drug cases, so a lot of our drug clients are absconding. Of course, the presiding judge who's been on the bench the longest has 218 bench warrants outstanding, which is probably more than double what the second closest judge has. And then we also submitted a third electronic monitoring report. It's really detailed and it's kind of cumbersome to read through because we itemize all the cases in which we applied. All right, so basically that's it for our stats here.
Presiding Judge, I know you had a question about the electronic monitoring last time when you asked them to put together the report. Do you have any questions?
Yeah, I have two questions on the bench warrants that are assigned to Judge Sokola because of our case assignment. When Judge Sokola retired, Judge Tolentino inherited all of Judge Sokola's cases. So you can assume that all the bench warrant issued by Judge Sokola will go to Judge Tolentino. On the second, I'm inquiring because, and this applies to APD as well. I just wanted to know that because in some of my cases, at least last week, I found out that some of the defendants were incarcerated for a few months, and I won't name attorneys, but in both cases, nothing was done to have them released. There was no motion for personal recognizance, no request for EM eligibility. So maybe Steve and Annie, I'd like to maybe have you audit and talk with your lawyers about these type of cases, because I'm the one that brings this up, and that's not my job to have these cases, these defendants released. I'm the one that. How come no motion for personal recognizance not been filed? No motion for electronic monitoring. And Annie was a beneficiary of my request last week. We won't name the lawyer. It wasn't Annie, just to clear her name. But it was another lawyer. He had two cases assigned to him, both assigned to me, and there was no movement. And the defendants were in jail for a few months. And they didn't even bother filing a motion for personal recognizance and or an EM application. So I'd like to have maybe Steve and Annie do an audit with all your people on pretrial. I'm the one personally always looking to make sure, especially newer defendants, that you guys do this, because I'm the one urging, and there's no argument from Annie, because she's in my courtroom all the time. First thing I see, if I don't see a motion for personal recognizance or EM, I ask, what have you done? And so, you know, you got to have audits and make sure you have these clients released. Okay? That's my belief.
No, no,
But-
we totally agree, Your Honor. I mean, there should be a bail motion in 100% of the confined cases.
Because once the magistrate judge incarcerates these people, the first thing the defense counsel should do, motion for personal recognizance or EM application. And I don't see that, really, just to let you know, I don't see that. I'm the one that has to raise these issues, and you know, that's not my job really, but I'm more concerned about the defendant incarcerated, you know, and I think you should talk to your lawyers. That's the first thing they should do if the defendant is incarcerated, file these necessary motions. It's not difficult to file these motions. I don't see what the problem is. I get the excuse, oh, we have to investigate this, we have to investigate that. Just file the motion and investigate later. But you know, because you know how long it takes to get a hearing in front of the magistrate judge, you know, both of you know that.
Yeah.
And so file your motion for recognizance and then have your investigators investigate. You will always provide that information later at the hearing. Yeah. Anyway, that's my beef. But overall, they're doing well. To answer your
All
question,
right,
CJ.
Thank you, presiding judge. Any other questions or comments? If not, you have anything else to report, Steve?
No, I mean, I think the budgets we'll deal with later in under new business.
Yeah, we do have it under new business as item C. So we'll now go to the APD's managing attorney, Annie.
Thank you, Your Honor. We did the report from August 1st to August 31st, and it shows that we have, year to date, we have 499 cases. And this, from August, the total amount of cases we got was 46. Could I address Judge LaMorena, Your Honor?
Sure.
Yes, I was in court, Your Honor, when you did bring that up, and it has come to my attention. And normally we do file bail motions on every client who's in custody. So I'll make sure we do an audit, and so for the next board meeting, we'll have an update on how many cases, or for each case that comes in, to have at least a bail motion for PR. So I'll have that for you, okay, Your Honor?
Okay, thank you. And I Steve, you should do that too. You know, the guys, if the magistrate judge says, you know, you're incarcerated, the first thing that you guys should do is file your motions.
Yeah, and that it automatically goes out, Your Honor. Once there's an email that goes out that you have a new detained client, it goes directly to the investigation division. And Robbie calls right here. He could explain the procedure. He's our acting AD and chief investigator. They automatically do a PR, EM, TPC packet, and so maybe he could explain if there's any gaps. But we don't believe there's a gap, so we'll follow up with that. I just I can't imagine an attorney here sitting on a motion for release. So
Because I do ask the attorney, how come a motion for personal recognizance hasn't been filed? Oh, we're still investigating, Your Honor. Well, you should file the motion anyway and investigate later, and then when the magistrate judge does hear the motion, you guys are ready, okay? You can't wait till the investigation is complete. Just file your motion for personal recognizance or EM. And then your investigators can investigate after the motion is filed. But you shouldn't wait until the investigation is done. By that time, the defendant, your client, has been in jail for a month or two.
no, I totally agree with you, Your Honor.
That's what I'm saying, okay?
Well, I think, Steve, it'll be good to get an audit. You know, we understand the high numbers of detainees at the Department of Corrections currently in the detention facility. And so I think it'll be good if you can examine all of the clients of yours that are detained and see if there's any opportunity to look for release conditions on all of them if they haven't already had motions filed, so we can look at that.
Yeah, and
Your
we're
Honor,
dealing
can I add to
with
this
an
story?
inordinate amount of revocations. So I have at least 10, 12 clients that are held on revocations. And if you're facing revocations, it's not likely you're going to get released, right? So that's the problem too. There's in the last year or two, there's probably been more revocations than I've seen in my entire career. And they're getting like, they're getting the full 3, 5 years, whatever they're facing. Maybe John could also, oh, I think Robbie wanted to say something.
I just want to make 2 points of interest here. So every new case that's opened within our front office, the attorneys receive an email regarding the new case assignment, and the investigator assigned to the attorney is also notified through that same email. And if we can go to page 20 of the statistics, regarding just September statistics, it shows, we have 308 detainees currently on pretrial status, but we also have 537, clients that are released under personal recognizance. Ken, can you switch to page 20? Page 20 on the
I see 309 and 532.
Yeah, so the one was September statistics for pretrial.
Oh.
Yeah, so is there another one before that one? I'm sorry, correction, on my part, what page is that? 18, page 18. So we have 308 individuals that are currently detained, 537 on personal recognizance. So it pretty much shows that a majority of the clientele are released under personal recognizance, either through a verbal or some type of written motion to the courts. So I believe the attorneys are keeping up. Of course, there's going to be some shortfalls, and obviously the 2 shortfalls came before yourself, Your Honor. And so that's unfortunate, but I think our statistics are pointing toward the direction where the attorneys are arguing and favorably getting release on these clients. So just the 2 points that I want to bring forward is that the from the onset of a case being opened up in our office, the attorney is notified, so is the investigator, the secretary is notified, and the statistics are pointing toward where the attorneys are arguing favorably for their release as opposed to losing the argument for detainment. So I just want to make that note.
The numbers are still a little high on the detainment. I mean, obviously, I don't know what the individual numbers are, but you're talking something approximating close to 38%, which seems like a high number for a percentage of detainees. But again, I don't know the details of the individual cases, but it'll be good to just examine the ones that are detained and see if any of them warrant consideration for motions or
Sure, and that's correct. And there are other release statuses like third-party custodianship, electronic monitoring, bail payments, so, and then the ones under pending are basically people that have come in with a notice to appear, they basically haven't had a magistrate hearing, they've just been given a notice to appear. And so they come in for consultation. So these people are not detained. So out of the total number, I mean, if you look at the total number of pretrial clients at 1,800, and you only have 300 people that are detained, I think the numbers are pretty good. I mean, obviously 800 are bench warrants, and we don't know if they're dead or alive or they're even on island. So
right, so you can't look at those 800 and the 1,800, Robbie. So I think you're looking at 300, 8 out of roughly 500 plus, because you have the 537, the 36, and the 10. I think those are the numbers that you'll look at.
And
Right.
Your Honor, we also have to look at the politics of it, right? I mean, we have people in their first offenders that are now being held on cash bail because the government is arguing for them because they're scared to stand up to him. We have people in jail for fraudulent use of a license plate, not because they were trying to defraud anybody, but because their original license plate was taken from them. So, I mean, we will try harder, Your Honor, but the reason we have 950 people in jail today, as opposed to 600 2 years ago, is not due to the lack of effort of my attorneys, all right? It's it's really a systemic problem. And I think our stats will bear it out. But we do fight for bail. In fact, I filed a bail motion in June that hasn't been heard in one of presiding judges' cases. So it kind of works both ways, right? So it's frustrating for us because we don't get bail motions heard like we used to in a timely manner. And I know that there are people who fall through the cracks, but we definitely will try harder because we don't want our people sitting in jail any longer than they have to.
Okay, just to add to that statement, one, I leave it up to the magistrates to exercise good judgment. That's why the chief justices appointed them and they were confirmed by the legislature. So I trust them to make good judgment based on the law, okay? And based on the criminal history and all the other factors. Two, I know that Robin and all of you are doing a good job, but if I'm the defendant, you forgot to file a motion for purchase recognizance, and I'm sitting in that jail, I would not be a very happy camper, okay? So that's why I want to make sure that there's some movement going in that case. If you're an attorney, you don't care because, you're not incarcerated. But you're the defendant sitting there and you didn't file a motion for personal recognizance. And you can just, those motions are perfunctory. You just fill in the blanks later at the hearing. Just have Robbie investigate later, And third, if you don't get a hearing, I always tell the attorneys, call up the chamber clerks and get a hearing, okay? You don't wait for the magistrate judge to set a hearing. If you bother them all the time, you'll get a hearing. And really, you will. Because sometimes things like, like for you, defendants fall through the cracks. Sometimes cases in front of them fall through the cracks. So you got to call the chamber clerks. We filed this motion about a month ago or 2 weeks ago, and we still haven't got a hearing. I think it's the obligation for the attorneys to call the chamber clerks of those magistrate judge. You don't wait for a case assignment or anything. You demand that you get a hearing date, and you will get it. But it's up to the attorneys. If you don't get a hearing date, go and complain in front of the chamber clerk. Chamber clerk will set a hearing date. I can guarantee you that.
All right. I think we've talked about this enough, and we'll now go to the report from the CLC managing attorney.
Can I just say one more thing
Sure.
before we forget?
All right.
I just wanted to say that September 27th will be my 20th year with APD. Just wanted to let you know.
Time's flown. All right. Report from the CLC managing attorney.
Good afternoon, everyone. So October, as we come to this, just so you guys know, we have activities for family violence. Our office is sponsoring a wave that's right outside our building, close to Halloween. We'll keep you guys posted on the date. I believe it's October 28, I think, and it's after work. But as far as stats is concerned, page 26 is our stats that deals with the at-risk veterans. We've to date have 13 cases that have been referred to our office. We were able to resolve 4 of them, including one that we filed in court on a landlord-tenant violation. So that's the veteran stats. Page 27 is our advocacy program stats. That's the protective orders stats. And that one we're still hitting about 10 to 15 or 20 cases a quarter. So right now we're at 10, but I think we add in the numbers for September. It's going to go higher. We've had about 82 clients on the advocacy year to date. And then page 28 is our civil law center statistics and our elder justice statistics. For the civil law center, we've serviced about 215 clients. Most of them are guardianships, as you can see in this matter, but we've also done other areas, but that's the bulk of the cases that we have under CLC. And this one also is where we do power of attorneys where they're income qualified as well. And then for the EJC, we've opened 465 to date. This quarter was 117. And the services, again, those are the amount of cases open, and then the services provided could be multiple services, which is why you'll see different numbers on the bottom of the stats where it says EJ total service. We also, on the EJC side, we've conducted, when they come in, we also ask them what other services they need. So we've been trying to seek what are the priority areas for this population. You can see the high numbers is deed of gifts, landlord tenant issues, name change and probate. Those are the areas that they continue to request services on. We've also now established an actual indigent risk needs assessment survey that will be allowing our clients to fill out so we can gauge the needs of the indigent population. That will be on SurveyMonkey. I apologize. And then Jackie Terlahi did appoint me onto a committee, which will help because then I can also gauge with Guam Legal Services and Micronesian Legal Services as to what services they provide, because I know they're very limited as well, but it'll allow us to make sure that we're not doing redundant or duplicate services to the community, make sure that we are able to give them services that they need that's not being provided.
Is muted. Any questions?
I have a couple of questions, Mr. Chairman.
Okay.
Carol, what is that utilities companies? What is that all about? I've
Oh,
never seen-
that's where they, so some of them have outstanding utility bills and some of them, so we're looking, actually, the one we're looking into, actually for it even, I think went up to, I want to say 10,000 in water and power bills.
Oh my
So what's going on is they're having a hard time, renting another place because now they cannot apply for utilities because they have an outstanding debt that accrued. And so that's some of the issues that they'll raise is that they have these bills that they weren't aware of, or the bills was too high. And so that's the stuff we've been getting from the veteran side.
Oh, okay. And secondly, you know, I've seen you process over 121 wills, right?
Yes.
Last wills. Do you file them at the Superior Court of Guam, or you just give them to the person that?
It's up to, so we give them the options that they have, and we tell them what options they have, because some of them actually have safe deposit box at the bank, or they have safes at home that they want to deposit in. So we give them that option. We do inform them about the court. We tell them that that's always, you know, that's going to be the preference because it's there in the court and it's, but they'll opt to say they just want to take it home, or, you know, they have a safe they're going to put it in, or they want to give it to a particular person, so that person is the one holding it. So it's like pretty much the client's preference, but we tell them about some of them have filed with the court, some of them opted not to.
Yeah, because you know, if they file in court, one of the advantages of filing in court is that nobody can tamper with the will because it's put in the vault. Whereas if they put in a safety deposit box, anybody who may have access, even after they, especially after they have passed away, can make changes or put another will in. That's what I, you know, because I've had a couple of probates where there were contested wills, where there was allegation from one set of heirs that this was fraudulent because the other set of people, beneficiaries, you know, doctored it or changed the will or something. So, you know, I just want to make sure to avoid any further controversies when the person passes away. Just to let you know. Okay.
And so, Your Honor, so we actually do keep scanned copies in our system as well. So if the court ever has any issues, at least if they feel like there was any tampering, you can always request that we appear in that court, and we'll produce at least what we have on our files.
Okay, so all the probate judge has to do is inquire with you, did so and so file a will with process a will with you, right?
Yes.
Just to guarantee that there's no it's contested.
Correct. Yes.
Okay, thank you.
Thank you.
Yeah, and Carol, before we used to file informal paupers, if they're financially qualified, and the court would waive the filing fee. I think it's like $50, right?
Is that still the position? Is that still what the court's going to do, Your Honor? If we file in paupers?
As a Chief Justice, I can't.
Or Manok.
I mean, I think if, obviously if there's a request to file, the court will take it under consideration.
Okay, I'll keep
All
that
right.
in mind.
All right, are there any other questions? If not, we'll go to the next item, which is the executive director compensation and classification. And it was my understanding, I know there's something that's been included, that was going to wait until the performance evaluations were completed. We do have the performance evaluations under items A and B for both the executive director and APD managing attorney, which we will discuss and examine and hopefully approve to undertake, in the next few days, or with the staff on the evaluation, and then for review by the Board of Trustees. But if someone was going to speak about that and talk about that just for informational purposes, we can go ahead and look at that information. Or explain it, or would you just prefer to defer it until
thought
the
that was
evaluations
just
are
gonna get
complete?
tabled until after the
Okay,
evaluation.
Yeah,
right.
I like to defer it until we get all the information before we make any comments.
Okay, so
I
we'll
don't-
wait till the evaluations are done and then do it. And then the next item is the Sixth Amendment Center projects.
Well, so the main project we're working on is the Sixth Amendment Center. After they did that report, they proposed a draft bill. So we reached out to David Caro and Adita Gual. They did prepare a draft bill. We met with the ABA task force on independence of the defense function, and so we're reaching out to nationwide experts to help provide input. We got a lot of interest from various think tanks. But more importantly, we did schedule a meeting with some of the court personnel, Danielle, Hannah, and Sarah. So they've seen drafts of the proposed draft bill, and we're still working through before we present it to the board. Make sure all our I's are dotted and our T's crossed. We also spoke to the Sixth Amendment Center about possibly reporting to the board. I don't know if you wanted us to see if they could maybe join in the next board meeting for a 15-20 minute Q&A session. And
Would the Q&A session be on the proposed legislation or just on the report itself?
I guess it would be up to the board. We're working on the draft. We should have something that we could circulate in a couple weeks, definitely before the next, like a couple weeks before the next board meeting. If you give us if the board wants to see it, say 2 weeks before the next board meeting, we should be able to have a working draft available there. We also invited Jay Ariola to talk on see if he wants to represent the bar. So we're going to have another meeting with all the parties and then try to work through this draft and see if we can have something we can present to the board.
Yeah, I think that before deciding whether they should report to us, particularly if we're talking about the legislation, I think it'd be helpful for us to actually get a draft of the legislation when it's, finally ready. And then, when we look at it, make that decision. I looked briefly, I haven't spent much time looking at the draft legislation. I just looked at it yesterday briefly when it was sent to me. And obviously we had talked about modifying the composition of the board and creating a commission that would be responsible for essentially in lieu of the Board of Trustees now, with different appointments, having members appointed by the Chief Justice, by the Governor, by the Speaker, and others. But it seemed, just in looking at it quickly, that at least the draft that was sent was much broader than just establishing sort of a new board to oversee the the role of indigent defense, and in fact talked about transferring monies, all of the monies in the Public Defender Service Corporation Fund, transferring all the employees of the Public Defender Service Corporation, all the property of the Public Service Corporation to this Public Legal Services Commission. And I don't know that that was really what was intended or not. And it seemed like it might have just been, cookie cutter legislation that might have been looked at from, other jurisdictions. But because obviously that's a much different approach than changing the composition of the board and looking at it if you're going to reconstitute the whole way in which public defender is being operated.
Yeah, so I mean, that's what I guess based on that report, these are the recommendations. And then we just added some of our proposed. Part of the reason is, alternate public defender, they don't actually exist in Guam Code annotated. They could get wiped out by this board really anytime they wanted to.
No, but
Same
the
as
public,
civil law
this
centers.
is not APD, this is PD.
No, I understand. So just be PD will be a equal division with APD and the Civil Law Center, so that there isn't really they'll all report to the commission independently, kind of like what we've been trying to.
Well, let's see the legislation, because this seems to contemplate an entire change of the Public Defender Service Corporation. And that's a much bigger, I mean, you're talking about a much bigger change than the composition of the board and who's going to be responsible for overseeing indigent defense, including, APD and PDs. This is actually making the Public Defender Service Corporation become the commission, become the board. It seems because of this transfer language. If you look at, it says the Public Defender Service, the following will be transferred from PDSC to the commission. All the monies in the PD Corporation Fund. So in other words, all the budget goes to the commission. All the employees would now be employees of the commission and not employees of the respective PD, APD, CLC. And all the property of the PDs would go to the commission. So it seems like it's just wiping out PDs entirely.
Yeah, no, I don't think that's intent. Yeah, so we could definitely clarify that language. Even like APD staff and personnel they'll just be transferred to a division underneath the supervision of the commission, as well as the civil law.
Well, I mean, that's why I think we want to see the proposal and it's before we decide to have them report. But this is more than just, when we were talking and they talked about having an independent commission overseeing indigent defense, this seems to be much broader than that, at least the one that was sent to me yesterday. Because it basically wipes out the Public Defender Service Corporation.
Yeah, we don't really want to do that. We just want to.
Yeah, I think that's a much bigger nut to chew than changing the commission, than changing the Board of Trustees to have a commission instead oversee the indigent defense. So I think it needs work and we need to look at that. And I don't know that you'll have that in 2 weeks, but you may. But I'd rather see that get done correctly before we decide what we want. All right.
All right. Thank you.
All right, then that takes care of both the Sixth Amendment, and now we'll go to the Executive Director performance evaluation. Actually, we might as well do both of items A and B together. I sent to the Board of Trustees as well, and it's been included in the packets. The draft of the performance evaluations for both the Executive Director and the Managing Director of APD and PD. The evaluations that are there, and including a link to the Survey Monkey plus cover letters. The surveys take about 11 minutes based on the estimate to complete the surveys. They are comparable to prior surveys that had been done on evaluations previously for PDSC. I think that the differences between the original evaluations that were done previously and these the ones that are here, they're subtle differences, but I think they show a shift towards a more strategic, concise, and modern phrasing with an emphasis on inclusivity and professionalism. And so I have put both of those evaluations out there, got some help in putting them together with HR professionals. And I'd like to get authorization to proceed with circulating these evaluation forms as a basis for us to then examine the results and meet as a board, and then talk with both the executive director and the managing attorney about the results of the survey. It's like a 360 evaluation, looking at it, and of course that gives us some feedback, because obviously our interaction with both of them is somewhat limited to our interactions either professionally or just here on these meetings, and we don't have the day-to-day interactions that others might have. And this is consistent with what's been done before. So first of all, does anyone have any questions about those different performance evaluations?
I have no questions, Mr. Chairman, but I would move to give you the authority to conduct the evaluations, and if any other members of the board wishes to.
I will second that.
If any other members of the board wishes to be with you for that evaluation, they have the privilege to do so.
I mean, these evaluations are going to be circulated to the employees of PDSC, and then the results will be compiled as they were previously when the evaluations were done. And then the board will meet and will look at those evaluations. The Survey Monkey has been set up so that I would ask for the acting executive director to, acting administrative director to circulate the cover letter to the employees of both of the PDs and APDs for them to provide their input. And then the results, including the link to the surveys. And then the survey results will be compiled, and then they'll be shared with the board, and we can talk about it and then discuss what the next step will be in the evaluation process. This is just one component of it, but it's something that we've done before.
So I so move, and I think I saw Director Kanata second.
Yeah, she seconded.
Yes,
All
I
right.
did.
So there's a motion to approve both of the evaluations and proceed with the evaluation surveys, and to proceed with that for both the executive director and APD. And it's been moved by presiding and seconded by Trustee Kanata. All those in favor say aye.
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 There being no objection, we'll proceed in that manner. So acting administrative director Robbie, if you can get that circulated, and let's just PJ, if you don't mind, maybe we can put a 2-week time frame to get those survey results done.
Yeah,
After
I don't
today?
object, Mr. Chairman.
All right, so let's look at trying to get those, give them a 2-week time frame to get it done, if we can. And that way we get all the employees done once the survey's been done, issued. And-
Chief,
Yes.
I just had a question.
the only question I had was the evaluation periods. Are we restricting it to 2023 to 2024? I think, at least with Ms. Gell, I think she's got at least a couple of years outstanding at this point.
I think there, I proposed that for both of them, at least, for me, I'm comfortable with, it looks like, a number of them weren't evaluated appropriately or timely, and it wasn't brought to our attention, but it'd be from the January of, I was proposing January through June from when I took over as chairman. So it would be January 1. I think the evaluations have that period, if I'm not mistaken, on it. It would be for the period from January 2023 to June 2024.
Your Honor, can I add something?
Yes, Trustee
I
Knapp.
know that Attorney Tulahi brought up a good point, but I think one of the reasons why we didn't do it was because of the situation that when COVID hit. And that was why we hadn't had a meeting per se, right? So that was one of the delays. Don't you think that should be noted somewhere in the evaluation? I'm just asking because there was such a, I mean, there was a lot of break in meeting. We didn't have the meetings according to the way we were supposed to have it because of that. So I'm wondering if somewhere that could be noted that that was one of the reasons why we didn't do the evaluations.
I mean, we can note that in the minutes now, but I mean, I'm comfortable with the period January 2023 to June 2024. And again, this is one step of the evaluation, as I said. And if we feel that after examining the other periods where it wasn't done, we can decide what we want to do. But I figured this was a good period to, I mean, it was the period since I came on as chairperson until June of 24. So we're looking at essentially that period, and the performance evaluations are clear that that's the period that we're looking at.
Your Honor,
Okay.
could I provide a little more information?
Yes, John.
So relative to our ED, he did have an evaluation period in 2020, but at that point there was financial uncertainty about what was going to happen since we were just entering the pandemic. So he told the board not to worry about it, that he would not take an increment at that point. And there was no effort to circle back to that when we realized that the sky hadn't fallen and that the finances were actually going to be okay. I think he should have had another evaluation period in 2022, but at that point, no action was taken, just I think for no reason at all. So per the legislation, he should be an classified employee. He's not. If he were, since he's worked here since the 90s, he'd be by far the most well-paid person on the staff, but he's not. He's unclassified. So I would just ask the board for the trustees to take all of that into consideration in trying to work out something that's fair for him moving forward.
Yeah, I mean, I think we've been aware of that, that he is aware of the conflict between the statute and the fact that prior executive directors were also not classified. I think they use that as an opportunity to recruit at a higher amount than the classified employees when there was a gap previously. And there is a summary on that was prepared by Robbie Call that's included in there, setting forth when the performance evaluations were conducted and not. And, obviously I'm sure the trustees will take all of that into consideration when we come back to examining not only the evaluations, but also the compensation and classification of the ED, which I think, the board wants to resolve. All right, so we do have that approved.
Can I just ask a
Sure.
clarified question? So I know Annie is just going to go to APD because she's the managing attorney for APD, but as executive director for all the divisions, should my survey go to CLC and APD as well?
I think it should.
I mean, I don't. I mean, do you interact with the APD attorneys?
Well, I think we make a lot of decisions that impact both of those divisions, so they should be able to provide feedback about that.
Yeah. Annie, do you have a position on that?
Well, I think for the most part, the lawyer, we do get together, but on an informal basis. I'm not sure if Steve, if the actual other employees would have any knowledge of how Steve is on a day-to-day basis with the public defender. But I mean, I'll leave that up to Steve. If he wants to have my office evaluate him, that's fine. That's just my opinion.
Well,
Thank you.
you know, just to make sure that our administrative staff is taking care of both CLC and APD, right? So that's part of the evaluation process, right?
Okay.
My only concern, Mr. Chairman, as long as it's only the support staff that is being evaluated, I'm just concerned about the line staff, you know, those who deal with, that's the reason why we had APD, is to avoid any conflicts of interest. And if there's if the lawyers and even the paralegals who are on the line are evaluating the director, I see that as a conflict of interest because, you know, there could be some concerns about his administration of justice and this. I don't object to the support staff, the people that do the accounting and all that.
I think if you look at the questions and what they're more targeted towards PDSC when relating to PDSC, and then APD as relating to APD. So I think we'll just leave it with the respective employees of each of them for now, Steve, and then we can, if we feel that we need to do something to get some input, you know, for example, on the overall management of those other things, then we can look at it. But I think it's best that it just the PDSC executive managers, and I think that was how it was done in the past, just go to the PDSC employees, and the APDs, managing director, go to the APDs. All right. All right, and so then the next item, and if there's no other questions on that, the next item is the fiscal year 2025 budget.
Oh, Your Honor, I'll just speak on that. So with the budget passed, it was such a grueling legislative session, but I think our office turned out well. We'd like to thank the board for your support. We basically got each of the divisions fully funded as per our request. The Civil Law Center might have, I mean, they asked for $1,031,000, but they got 950,000. So they'll be able to live with that. I know that Carol's going to address that next. But really, the public defender, basically, they actually gave us more money than we asked for. But that was due to the increase in the unfunded liability of the retirement fund. So that amount increased. So yeah, we're really happy with the way the budget turned out. We want to thank all of you for supporting our budget requests. And, you know, I mean, as we enter our 50th year, I think there's going to be a lot of exciting things that we have planned. So, which leads us to Carol.
Do you want me to proceed, Your Honor, or on the next
Did anyone
item?
have questions about the budget?
Any questions about the budget first before we go to the next item on the moratorium? All right, there being none. The next item is the Civil Law Center and the budget separate appropriation from the general fund to fund the Civil Law Center, but it was subject to provisos that it's contingent upon the lifting of a moratorium currently in effect, with any future limitations based upon the capacity and the priorities of the Civil Law Center. So I'll recognize Carol to talk about that.
Thank you, Your Honor. So basically, we did get funding from for this budget year. They funded us 950,000, a little over 950,000. And what we're trying to do is, at this point, we'd like to request that the moratorium be lifted. What we will do is, of course, again, identify the needs that are that are necessary for our indigent population. And this would help us too as we transition out of ARPA. We will still be able to set like age requirements for our Manamco, since Guam lost 55 and our EJC only provides services for 60. We'll be able to, work on setting program eligibility, but for the most part, it's going to be income based under the Civil Law Center for all other services that are not for the Manamcos. And we service veterans at risk and tax. So those are all under their programs, and they'll continue to be under their programs. This will be based on income eligibility. And like I mentioned earlier, thank you, Jackie, for putting me on that committee. I'll be able to address the needs of what's being serviced by the other providers like Guam Legal and Micronesian Legal, who also service indigent. They're also very specific and limited to what they do, but I want to make sure that our services flow and we're not redundant, and also the creation of other programs in this office that will assist the community and the Guam Bar and the courts, of course. So we're asking that the moratorium be lifted. And again, it's based again on priorities, as you mentioned, Chief Justice, and the capacity and resources provided to our office. That would make the determination as to the services we would provide.
Carol, we had talked about trying to get a proposed resolution to the board in advance that we could look at. And were you able to do that?
I believe they might have sent it out. I'm not, but I
didn't get any.
Oh,
I didn't get a proposed resolution for that at all. And secondly, I mean, I know you're talking about. I went back and looked a little more carefully at the provision in the budget law, and I know that we had a prior when the PDSC 520, when the moratorium was lifted to establish the Civil Law Center and do the LAS program that was administered by Public Health. But there is also language in the end of Section 4 that talks about only providing legal services to indigent senior citizens, victims of domestic violence, and veterans. So if you look at Section 4, so, I just want to be clear, what is it that the moratorium is going to, because it seemed like there was some discussion about doing other things, but it seems like the appropriation might be contingent on, is based on providing these types of services.
so we discussed at the budget hearing, Your Honor, and we discussed with this, it was our intentions at the budget hearing that we would be expanding the services that we do provide, but we would take into account the fact that we're not going to take cases like that are fee generating, where it's strictly for indigent clients, and then we would determine which cases we would take. One of the things like I spoke about was assuming like the guardian ad litem and PINS cases for the court, it could be directed to our office, and also Micronesian Legal and Guam Legal as the defaults for court appointments. That way, the private attorney panel that exists for juveniles can be appointed to the parents or to the juvenile and delinquency matters. And then other things that we're looking at, again, is like an expansion in like assisting families where they're having issues because although they're not divorced, they've been legally separated for 10 plus years or more. And now they can't apply for public assistance because they can't afford an attorney. They're still married. So GORA is still counting, or other agencies are still counting them as the husband as head of household when he's not even with the individual anymore. So we're just trying to assist like the indigent population so that the benefits that they can receive are not affected. And looking at, of course, other areas that we deem as not being serviced by the other two legal service offices.
Yeah, and can I just add, so the resolution was sent out 10:15 this morning, so it's somewhere in the inbox, hopefully. And then but the language that it looks like it just identifies that you can lift the moratorium, the board has authority to lift the moratorium, and that if in the future any limitations will be based on the capacity of the Civil Law Center and of course continuing the priorities of their current priorities of legal services to indigents, victims of domestic violence and veterans. So I don't think it precludes a general lifting of the moratorium as long as it's based on, obviously CLC needs to develop the capacity, right? Because we don't know, we can't open the floodgates because the year we imposed a moratorium in 2003, we opened 203 domestic cases.
Can you pull the resolution, then the proposed resolution up on the screen? Yes, I didn't, who sent it to us?
Oh,
Yeah, Chief, I'd also like to see the section of the public law granting.
Yeah, can
the
you pull up
authorization.
both of those then?
okay. Yeah, I could do that if they allow me to share.
Your Honor, it was sent at 10:15 by Felicia M. Cruz. So if it might have went into, if you haven't received anything from it, it might have went into junk or spam.
Oh, that, well,
This
I
is the
got,
budget.
okay, I see it. Yes, I got it. I know what didn't go into junk mail. I just didn't see it come in before the meeting. I was looking at. So if you can pull up the resolution
Oh, so,
and
my
then
sharing
pull up the public law.
okay, I have the.
All right.
So
I do
here's
have the resolution in front of me as well from Felicia.
Okay. Here's the resolution. I don't know why it's not a good copy. So this one just identifies the original moratorium of 2003 and then the continuing resolutions over the years. And then it discusses the creation of the Elder Justice Center and then Resolution 13. Oh,
Steve, that version is really rough.
yeah, maybe
on the display.
You just
I'm
open
not
the
sure.
other one. Go
Must
back
have
to it.
downloaded a bad copy for some weird.
No, just click on one and then go back to it. It should reopen it.
Ken, could you put a cleaner copy on? I'll stop sharing mine.
Try to reopen it, Steve.
This is the language in the
Yeah, this is the language in the budget law, except
Budget Act, Jackie.
Thank you.
So it is the appropriation is contingent upon lifting the moratorium. So currently in effect, and then with the proviso of future limitations based upon the capacity and their priorities to provide these services. So I do think it's not a restriction to provide services to injured and senior citizens, victims of violence, and veterans only, but that if there's a limitation in the future, that has to be the priority.
Then let me get a cleaner.
So
Do you have a cleaner copy of that resolution?
I do not, I was not.
I have a copy of it. I'll share my screen. All right, you can see my screen?
Yes, we can, Your Honor.
All right. So this is the resolution. And it talks about first imposing the resolution, and then it was made indefinite, but then that was modified by 520 based on, providing under the last program with DPHSS, and then Resolution 123, which established the Elder Justice Center, and then now the civil legal services being performed by the Civil Law Center, and mentions the appropriation, which is contingent on the lifting of the moratorium, and that executive director, that the appropriations will allow for continuous legal assistance as mandated under 12 GCA 1105, especially and without compromising the scope of work and because of and no conflicts of, or minimizing the conflicts of interest because of the establishment of the Civil Law Center as a separate entity. And that the moratorium is lifted and will be subject to any federal grants or based on who qualify, and Civil Law Center. So that's the resolution.
Your Honor, I have a question
Yes,
on the resolution. Isn't the legal age on Guam for senior citizens 55 and not 60? Is there a reason why is it 60 and not 55? And if so, can we change it?
Oh, no, so the grant covers 60 and older, so because we're locally funded, we'll be able to assist 55 and older. So that'll be one of the first. I mean, I think we're already helping them, right? 55 and older, and with using ARPA funds.
I don't know that. Should that be stated? I'm
Yeah.
just asking
Yeah, no.
because
this is under that whereas clause references
Mhm.
federal grant.
And
Yeah,
Chief Justice, I've
Yes.
got a motion at this time. I'd like to motion to table this for our next meeting. I think that this is an extremely important issue for which the Guam Bar Association should be participating in. That kind of by not raising this issue to table it for the next meeting to notify the bar that the Board of Trustees is considering a complete lift to the moratorium and the reasons why that should or should not be undertaken. I think that that's an issue that affects the entire legal community, and such. I would be derelict in my responsibilities not raising that issue at this time.
So there's a motion to table. Is there a second to that motion?
I'll second that motion.
All right. I would note that before we take a vote on it, that the appropriation is contingent on lifting of the moratorium. The fiscal year starts on October the 1st. And so I would want it to be addressed no later than the next meeting. And also, it's clearly they're only going to be serving the indigent population. I don't think it's something that the Guam Bar is focused on serving. We have a difficult time getting pro bono representation and indigent defense on the criminal side. And so I don't think that this is something, but, there is a motion and it has been seconded. So with that motion, I'll take a vote. All those in favor, say aye.
Aye.
One aye. Trustee Lamarena,
I'm abstaining. I just wanted to entertain the motion so that it can be discussed.
Trustee Whitman,
I'm so sorry. What was that?
there's a motion to table this until the next meeting. It's been moved and seconded. Presiding judge has abstained. Attorney Tolahi has voted in favor of it.
Oh, yes, vote in favor, please.
All right, so there are 2 votes in favor, 1 abstention, and I'll vote in favor of deferring it just for 1 meeting, just to give the Guam Bar an opportunity to put in. I don't think it'll undermine us. It's important that we get that moratorium lifted, and I'll push to make that happen at the next meeting.
sir, I have one question though.
Yes.
May I please, if I can?
Yes. I forgot that you were there. I should have gotten your vote first before I voted mine. Trustee
Yes, sorry.
Knappen?
Sorry, sir. I mean, you know, it wasn't a fun ride when we appeared before the committee, I mean, for our budget. They gave us a really hard time. Are they gonna use us not making this effective on October 1st because we didn't approve this motion? Hold it against us and not give us the budget at all? Because I'm thinking this might, if we don't approve it, they're gonna give us a hard time with our budget. I mean, it was really hard to get our budget approved.
The budget is passed, Donna.
I
and
know that, but
Yeah.
I know it's passed, but I'm just saying, is this gonna give anybody the right to go back and say, because we didn't lift it, we shouldn't have gotten that funding? I'm just asking a question. I don't know the answer to that.
I think, I don't think there's gonna be a problem. I think we will lift it. And it'll be lifted in time to realize the full amount of the budget.
Okay, I just wanted to make sure.
Can I also
So-
speak, I guess, just so Jackie, I can clarify some issues. The plan isn't to just jump in and open everything. We're gonna get input from the Guam Bar. And before this board, before we make a decision, we're definitely not going to stop the services on those clients that you see listed in all, which is our indigent, our veterans at risk, and the TAC. We'll continue to provide those services as well as the other under all these resolutions, we're allowed to do uncontested guardianship. So we've continued to do all of that. But before we open up anything else, we just wanted to lift the moratorium. As far as what we're going to set in needs, that could be something that we also look at input from the Guam Bar on. Because we're not just going to jump in and open up everything at this point. We want to get the input, from the other two providers, which is why it's kind of good that you put me on that committee, because I'll be able to get the input from the two others that provide also for indigent, to make sure there's not repeated services, and to make sure that when we look at the needs, we're addressing the high priority needs of them, because the resource and the staff is what we're in this office. We're a small office. So we're balancing everything. And so we have no plans to take any fee generating. Yeah.
Yeah, Carol, let me be clear. It's not that I oppose the lift of the moratorium. It's simply that I was provided this resolution just today. And so it's important that when we take such a massive step, that we get the input of those who are in the bar, because they are the stakeholders of kind of the impact that we may see. I already see that one major criticism is going to be if this civil law center is walled off, then they should be added to the criminal appointment list, just like small firms are added to the criminal appointment list, you see? Because they're going to say, wait a minute, then they can act also as a conflicts counsel. So these are some of the concerns that I've heard from the Bar Association already, and that's without receiving this resolution. And that's why I'm simply asking for just some time. I'd like to provide the bar the full resolution that's being proposed, and also provide them notification that we are gathering to address the issue, and provide them the statute that you've already been giving this funding, and we don't want to lose this funding. We'd like to see this move forward. But I want to give them an opportunity at least to provide the concerns, so that way you can address some of those concerns in the course of receiving the budget and acting.
Yeah, and I just want to say that when PDSC was created in 1975, really, Guam is where Civil Gideon's day began. In Civil Gideon wasn't even a phrase in 75. And so, we're gonna celebrate our 50th next year, and we plan on having our, that ability restored. So, just for the staff at CLC, we'll have funding to carry us through until the moratorium gets lifted and we get full funding.
I would note that the resolution does contemplate that the Civil Law Center has to determine the type of services and representation by looking at a community needs assessment. So in addressing Trustee Kanata's concern, that still has to be undertaken before. So even I don't think that the lifting of the moratorium in October will necessarily jeopardize the budget or how that is going to be spent. All right. so the resolution has, what's your vote, trustee Kanata?
I'll pursue, I'll approve it until the
All right.
October, but not after that.
Okay, yeah, all right, so it's been approved and we will table this until the next meeting and vote accordingly to give the Guam Bar Association opportunity to review it and provide any input to the board in advance of our lifting of the moratorium next month. All right, we now will adjourn, recess and convene into executive session. Do you have a breakout room set up for us to go to that?
We do, Your Honor. I just need 30 seconds to get everyone in.
Okay, and I'm going to ask just at the beginning of executive session to have Mr. Moreno stay behind, and then we will talk in executive session and then come back afterwards.
Sir, can I ask,
Yes,
is executive session gonna be recorded? And are there minutes gonna be taken?
yeah, we will have to take minutes. So I think,
But it's not recorded.
no. We can end the recording or decide when we get to that part.
Okay.
Just hang on, you'll be put into a breakout room, I think. They've got to move us into a breakout room. And so you can just put stop and join if you see that in All right.
I'm back.
We are now recessed from the executive session and are back in regular session. And I will now recognize Attorney Terlahi.
Thank you, Chief Justice. Chief Justice, at this time, I have a motion. First, I'd like to acknowledge that the Board of Trustees has received 3 grievances since our last public meeting for the Public Defender Service Corp. And in light of the fact that we have a policy to resolve as quickly as possible all grievances, while we recognize that there is a grievance process, my motion would be that since the complaints were addressed to the Board of Trustees, before determining a appropriate course of action, that the board should direct the persons to whom the complaints are against, that those persons should lodge an answer with the Board of Trustees, directly to the Board of Trustees, within 10 working days so that we can determine a proper course of action.
Right. And it's unclear whether they were grievances, complaints, whatever they were. So I think that is an appropriate course of action. So there's a motion by Trustee Terlahi. Is there a second?
Second.
All right, it's been seconded by Trustee Kanata. All those in favor say aye. Aye. There being no objection, the motion passes. So we will ask those who have been complained about to provide a written answer so that the appropriate, within 10 days, so that the appropriate course can then be decided of what the next step will be concerning the process. And with that, is there anything
Your
under
Honor,
public
can I just
discussion?
say something for the record?
Yes.
So, we received wind of these complaints a couple months ago. We didn't have any names until just recently, so we've not conducted any investigation or sought, to advise them of the grievance procedures that exist in our rules. So I don't want people thinking we're trying to muffle anybody's voice. They just
No, I don't think that anyone believes that, Steve. And I think, as you know, under the PDSC, what we're not sure about currently is that whether or not the grievance process is appropriate for this. And so, that's why we felt that it would be important to first get a response, and then we can determine whether it should go through the grievance process once the response is done. As Jackie indicated, the process is to try to get them resolved as quickly as possible.
and due process as well, right?
Pardon?
With due process as well, right?
Yes, absolutely. And also without any fear of interference, coercion, discrimination, or reprisal against any of the employees that might have complained.
Yeah. Oh, absolutely.
Right. And of course, that's and part of why we want to get the responses then to determine, is this appropriate for the grievance process, or is the grievance process have shortcomings that it can't address what has been done, and something else needs to happen.
Okay, and so could we have a deadline for the people being grieved against to receive notice so that they can?
We're gonna send all of the complaints to them today.
Oh, okay. And then the 10 days.
And then they'll have 10 days after they get them, but they'll receive them all today.
Okay,
I'll
great.
work with the acting administrative director in confidence, or to have those complaints distributed to the people who they've addressed to.
Okay, and just to let the board know, will Robbie Call be acting AD until we either hire the replacement or we resolve these issues, just to avoid any concerns about.
Or I may even just have someone from the judiciary send them directly to the employees, just to show the sense of independence.
Yeah, that's fine.
Okay.
That's a good thing.
Thank you. That's fair.
Yeah. All right. Is there anything under public discussion? If not, can I entertain a motion to adjourn?
Motion.
All right, it's been moved by presiding judge, seconded by Trustee Kanata. There being no objection, the Public Defender Service Corporation will now stand adjourned. Thank you.
Thank you.